rise for the jury.
First back in session, you may be seated.
All right, number 2 is if at any time you cannot hear me or witness, please raise your hand if you are attention. At this time, I'm going to provide you with some instructions. This is the trial of the criminal case. The defendant, Owen Cunningham, is charged in the complaint with leaving the scene of property damage, negligent operation of a motor vehicle, and failing to stop for the police. In every criminal case, the defendant is presumed to be innocent unless proven guilty beyond a reasonable doubt. The law requires the prosecutor, who represents the Commonwealth, to prove that the defendant is guilty beyond a reasonable doubt. The law does not require the defendant to prove his innocence or produce any evidence. At the end of the trial, you must find the defendant not guilty unless the Commonwealth has proved to you beyond a reasonable doubt that the defendant has committed the offenses with which he is charged. As you have heard, the defendant is charged with the crimes of leaving the scene of property damage, negligent operation of a motor vehicle, and failure to stop for the police. The Commonwealth must prove each of the elements which make up those crimes. At the conclusion of the trial, I'm going to provide you what those elements are, and in much greater detail tell you about the law which you must apply to this case. The trial will proceed in the following order. First, the prosecutor will present an opening statement. The defendant may choose to make an opening statement immediately, may postpone doing so until later, or may decide not to do one at all, since the burden of proof is always on the Commonwealth. The opening statements are an opportunity for the lawyers to explain what the trial is about. They are not evidence. The prosecutor will present evidence first. Then the defendant may present evidence if he wishes, but he is not obligated to do so. Remember, the burden to prove the defendant's guilt is always on the Commonwealth. There is no burden on the defendant to prove his innocence or produce any evidence at all. After the evidence is presented, each side will make arguments about the conclusions you might draw from the evidence. I instruct you that the closing arguments of the litigants, like their opening statements, are not evidence. After the closing arguments, I will instruct you in detail on the law that you must apply during your deliberations. Your function as a jury is to determine what evidence to believe, how important any evidence is that you believe, and what conclusions all the believable evidence leads you to. You are the sole and exclusive judges of the facts, and in determining what those facts are, you should draw on your own common sense and life experiences. Our system of justice requires you to render a fair decision based on the evidence, not on biases. In evaluating the evidence, determining the facts, keep in mind that everyone, myself included, makes assumptions and forms opinions based in part about likes or dislikes, opinions, stereotypes, perceptions, and prejudices arising from our own personal backgrounds and experiences of which we may not be aware. These assumptions and opinions can impact what we see and hear, how we remember what we see and hear, and may cause us to draw generalizations or to prejudge. Because you are making very important decisions in this case, you must be alert to recognize any potential bias that might affect your view of the evidence in this case. You must not allow bias, conscious or subconscious, to interfere with your ability to fairly evaluate the evidence, apply the law as I instruct you, and render a fair and impartial verdict based on the evidence presented at this trial. My job is to see that this is a fair trial and to decide questions of law. If during the trial one of the litigants makes an objection, I will rule on it. It is the litigant's responsibility to make appropriate objections, and you should not look negatively on any of them for doing so. If I overrule an objection, you may consider the answer. If I sustain an objection, you may not consider the answer in any way whatsoever. Finally, you may not discuss this case with your fellow jurors until your deliberations. You may never use a cellular telephone or electronic device for any purpose regarding this case, nor may you discuss this case with family members, friends, or on social media until after the verdict is announced in the courtroom. And I just have one more note I want to provide you. The defendant has decided to represent himself in this trial and not use a lawyer. He has a perfect right to do that. His decision has no bearing on whether he is guilty or not guilty, and it should have no effect on your consideration of the case. So finally, I know that you will try this case according to the oath which you have taken as jurors, in which you have promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath and try the issues without fear or prejudice or bias or sympathy, you will arrive at a true and just verdict. Commonwealth?
Hello. Again, my name is Edward Walsh. I'm the Assistant District Attorney for the Middlesex DA's office. And we're here today mainly because of poor decision making. Poor decision making on the part of the defendant before you, Owen D. Cunningham. You're going to hear from Officer Ryan Sheehan that when he was on patrol in the fully marked police cruiser on Main Street in Tewksbury, Republic Way, you're going to hear him talk about on November 5th, 2024, at approximately 1:30, he observed the vehicle. The reason it got his attention was because that vehicle on Main Street went up onto someone's lawn. Went up into someone's lawn and just kept driving down Main Street. So he followed. And as he continued to follow, he saw the vehicle then pass over the little yellow lines and strike another vehicle and keep going. Again, you're going to hear from Officer Sheen. He'll tell you that he put his emergency lights on at that point. And for the next over a half mile, that vehicle didn't stop. But we ran an inquiry. He was able to see whose vehicle it was. He was able to see the individual who was behind the wheel. And eventually, after that half mile, he kept looking back at him, eventually stopped. Officer Sheen gets out of his vehicle, goes to approach the defendant, and then the defendant just takes off. Officer Sheen gets back into his vehicle. He notifies other officers. You're going to hear about a stop that they tried to do with other officers, but the defendant just went around. Eventually, Officer Sheen was able to locate the vehicle, but the defendant was nowhere to be found. And you'll hear that eventually he was discovered and was arrested. At the end of this, I'm going to come back to you and I'm going to ask you to find the defendant guilty of failure to stop the police, being seen of property damage, and negligent operation for motor vehicle. Thank you.
All right, thank you. Mr. Cunningham?
I do. Is it okay if I do it from here? Good morning. You've just heard from the Commonwealth about my actions this past election day, and the Commonwealth is here to convince you that those actions constitute crimes. And even though I stand before you speaking in my own defense, I want to encourage you to believe them. What do all crimes have? Means, motive, and opportunity. And the Commonwealth will show in great detail how my actions this past election day fit that pattern. They will show that the Ram pickup I was driving that day constituted the means for these alleged crimes. They will show that election day itself constituted the opportunity for these alleged crimes. Ladies and gentlemen of the jury, when the Commonwealth speaks to you today, I want you to listen carefully. Anything they say factually about means or opportunity, you should believe. And why wouldn't you? The Commonwealth is staffed with well-trained and highly dedicated men and women who have integrity and a desire to do the right thing. Over the last 8 months, I've had an unprecedented opportunity to see these people operate up close and personal. And as tempting as it might be for someone in my position to demonize them, I just can't. The Tewksbury Police Department, the Middlesex County DA's office, and even the Wilmington Police Department, which patrols where I live, next door to Tewksbury, are all good and honest people. They have no reason to lie or to conceal anything from the public or to manipulate the citizenry they serve. So when it comes to means and opportunity, as they pertain to the facts of this case, the Commonwealth speaks with authority. But you will notice that the Commonwealth lacks the same authority when it comes to motive. On Election Day, the Commonwealth had no insights into what the motivation was for these alleged crimes. OUI DUI was ruled out when I was first taken into custody. Mental health crisis was ruled out within the first hour after booking. No hate crime charges were filed. Motive matters because in criminal law, intent matters. Now, how much intent matters is up to you, or will be up to you in the end. But we can say at the outset that it does matter to some extent. When I woke up on the morning of Election Day, I had no intent to drive at an unsafe speed, even though the Commonwealth may well show that I did. When I woke up that morning, I had no intent to sideswipe another vehicle with mine, even though the Commonwealth may well show that I did. And when I woke up that morning, I had no intent to flee a traffic stop, even though the Commonwealth may show that I did. But when I woke up on the morning of Election Day, I did indeed have a specific criminal intent in mind. When I woke up that morning, I had full intent to get myself arrested for interfering with the presidential election that was underway. When I woke up that morning, I intended to engage in an act of nonviolent civil disobedience and get arrested for it so that a record of my outrage would be registered with the government. In other words, when I woke up that morning, I had the exact same intent as hundreds of Trump voters claimed they had when they converged on the U.S. Capitol on January 6, 2021. I will be taking the stand as part of this defense, which everyone has assured me I shouldn't do. During that testimony, I might make one or two minor disputations of fact against the account presented by the Commonwealth here and there, but the main thing I'll do is explain what sort of necessity, legal necessity, or justification that these Election Day events could possibly have had. Ladies and gentlemen of the jury, you will either find in my testimony a justification or you won't. And that simple yes-no answer should, in my view, be the single largest consideration you take on board when deciding to find me guilty. One last thing. The only reason I'm here presenting this defense is that ultimately, thankfully, no harm was done. Even the Commonwealth agrees that no human beings were injured or killed. Even the Commonwealth agrees that no property sustained any specific dollar amounts worth of damages. If this weren't true, if persons or property had been harmed, I wouldn't be here. If my conduct on Election Day had actually done harm, I wouldn't have the chutzpah to stand here and try to defend myself in front of you, my fellow citizens of Middlesex County. If my conduct on Election Day had actually done harm, I would have entered a guilty plea from the get-go. I believe my conduct on Election Day came from motives that are valid. But even I can't pretend that those motives are more important than human life and safety, because they aren't. If at any point in this trial the Commonwealth introduces evidence or testimony that substantiates the opposite, that a human being was injured or that property did sustain some specific dollar amounts worth of damage, then I will abandon my defense and move to change my plea to guilty. I care about my own freedom, obviously, but only because I know I haven't done any real harm. Had I inflicted real harm, I would care about that more and would agree then that my freedom would deserve to be curtailed. Thank you.
Thank you, Your Honor. I will call security use officer.
solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do. Good afternoon. Good afternoon. Please have a seat. Thank you, Your Honor.
Come up whenever you're ready.
Thank you, Your Honor. Can you state your name and spell last for the record?
My name is Brian Sheehan, last name is spelled S-H-E-E-H-A-N.
Are you employed?
I am.
By whom?
Tewksbury Police Department,
What's your position?
patrol officer,
How long have you been in this position?
2.5 years.
Did you attend an academy?
I did.
Where did you attend?
Linfield, MPTC.
When did you graduate?
I graduated July 2023.
When you were at the academy, were you trained in investigating negligent operation of motor vehicle cases?
Yes, I was.
What did that training consist of?
That training consisted of being able to observe certain Chapter 90 offenses.
Are there any, what specific offenses would that be? Can you give me some?
That may include speeding, marked lanes violation, hands-free violation, so on and so forth.
In your time as an officer, you executed motor vehicle stops? Can you approximate how many?
That would be tough to do, sir. I approximate between 100 and 200.
I'd like to know the events of November 5th, 2024. Were you working that day?
Yes, sir.
What shift were you working?
I was working the 8 to 4 patrol shift.
Were you in uniform?
Yes, I was.
Were you operating in a fully marked police cruiser?
Yes, I was.
Where were you operating at approximately 1:30 p.m.?
On Main Street in Tewksbury.
Can you describe Main Street in Tewksbury?
Yep, Main Street in Tewksbury, also known as Massachusetts Route 38. It's a public way. Travels all the way from the border at Lowell to the border at Wilmington.
How many lanes does it have?
2, one in each direction.
Who has access to that road?
All of the public has access to that road.
And who maintains it?
The state of Massachusetts, the Commonwealth of Massachusetts.
At approximately 1:30, did you make any observations on Main Street?
I did.
What were those observations?
I observed a white Dodge Ram pickup truck traveling northbound in front of me. At that point, I witnessed the vehicle pass the vehicle that was in front of him on the right-hand side, which essentially I watched the white truck drive through the front yard of a residence to make that pass and then continue northbound on Main Street.
What did you do when you saw that?
That particular day, due to traffic being election day, I withheld from conducting an emergency traffic stop, just like I said, due to the traffic, but I continued to follow that vehicle and pay close attention to its actions.
You said it was election day. Was there pedestrian traffic?
Yes, there was. It was heavy pedestrian traffic.
As you continue to follow that vehicle, did you make any other observations?
I did.
What were they?
The next intersection would be Main Street at Chandler Street, all public ways. At that point, I witnessed the white Dodge Ram pass another vehicle illegally over the double yellow lines this time, so the pass was made to the left-hand side, whereas the first pass was on the right-hand side. This pass to the left-hand side through the intersection, the Dodge Ram collided with another vehicle and then continued to drive away from the scene of the accident.
Do you see what side of the vehicle the Dodge Ram collided with?
It would be the right side of the Dodge Ram to the left side of the vehicle that was struck.
What did you do when you observed this?
The moment that I saw that, I turned on my emergency lights and sirens to conduct a traffic stop on that vehicle.
And did that vehicle pull over?
They did not.
What did it do instead?
I continued to travel northbound on Main Street without stopping.
Did the vehicle eventually stop?
The vehicle did eventually stop.
How far can you approximate did it travel?
Approximately a half a mile before it came to a stop.
Did you make any observations of the operator of that vehicle as it continued to go?
I did. During that time, I slowed down just prior to coming to a stop. I was able to enter the license plate of that vehicle into my database in the computer, the seizure system, which provides me with the information about the vehicle, which includes the registered owner. So now I have the photo of the registered owner of that Dodge on my computer next to me. And several times throughout, the driver of the Dodge not coming to a stop, I witnessed the which was easy for me to determine that is the registered owner driving based on my looking at the RMV photo also right next to me.
How close were you able to get to the operator of that vehicle?
When he came
When
to-
he was driving?
When he was driving, approximately 20 to 30 feet.
You said the vehicle ultimately came to a stop.
It did.
What did you do then?
At that point, I exited my patrol car after radioing dispatch to let all officers in dispatch know what was going on and where I was.
How close did you get to the operator of that vehicle then?
Just about the rear of the truck, so from the back of the truck to the driver window was about where I was.
And you were able to see the operator?
I was.
Do you see the operator of that vehicle in court today?
I do.
Can you describe that individual by an article of clothing or not?
Wearing a
Your Honor, please let the record reflect that the witness is identified.
There you go.
What happened when you approached the vehicle?
When I approached the vehicle immediately poured the gas pedal and left the scene.
What did you do next?
I returned to my patrol car and followed in the direction that he had left.
Did you use your radio at that time?
I did.
What did you say over the radio?
I informed the other officers in dispatch of the direction of travel of the vehicle, that it had left my traffic stop and was now speeding again northbound on Main Street.
Did you make any observations of what other officers did?
I did.
What were those observations?
As the vehicle continued to travel northbound on Main Street, approximately a quarter mile after where that initial stop was, is the first with their lights on at the edge of the parking lot right on Main Street, as well as officers in marked units on Main Street with their lights and sirens on, indicating for this ramp to come to a stop.
And did the vehicle stop?
It did not.
What did you observe it to?
I observed it continue to travel northbound on Main Street, weaving his way between patrol vehicles, almost collide head-on with a lieutenant in a Chevy Tahoe marked unit, and then continue driving down Main Street.
What did you do next?
At that point, I had continued putting out over the radio updates on speed, direction of travel, which has pretty much stayed the same most of the time. And that is when I was, all officers were called off of the pursuit by the deputy.
Were you ultimately able to find the vehicle?
Yes.
Where did you find that vehicle?
Approximately 5 to 10 minutes later, we got a call from a business owner of a mechanic shop, which is probably another mile north. And he said that a white truck just came barreling into his parking lot, almost struck 2 pedestrians. The truck drove to the back of the parking lot, the operator exited the truck, and then fled on foot into the wooded area behind the business.
And did you go to that business to see that truck?
Yes, I did.
Were there pictures taken of that vehicle?
Yes, there was.
Your Honor, may I approach? Thank you, Your Honor. Just these ones.
Okay.
Just 1, 2, 3. Officer Sheehan, what did I just hand you?
Photos of the defendant's vehicle, sir.
How many photos are there?
There are 3 photos in front of me, sir.
Do you see anything on the second and third photos?
I do.
What do you see?
Damage to the vehicle.
And is that damage on the vehicle? Is that consistent to what you observed earlier in your pursuit?
Very much so.
And would you say that these pictures are a fair and accurate representation of the vehicle on damage?
Yes, they are.
Your Honor, the Commonwealth would move to enter into evidence these photos.
No, Your Honor.
All right, that'll be exhibit.
And getting back to when you said that you had brought up, you conducted a CJIS inquiry,
I did.
and you saw the photo of the individual.
Yes, I did.
Your Honor, may I approach?
You may.
And Officer Sheehan, what did I just hand you?
These are documents from the Registry of Motor Vehicles, Massachusetts RMV.
And what do you see? What do you see on that? Do you see on that license?
I do.
And what do you see on that license?
The license is issued to.
Is there? I'm sorry. Is there a picture?
There is a picture on the license, yes.
And that was the individual that you pursued.
Yes, it is.
Your Honor, the Commonwealth would move to enter in the Registry of Motor Vehicle documents, the license image, as well as.
No objection.
When you learned the location of the vehicle, was the operator present?
He was not.
Was eventually the operator located?
Yes, he
And
was.
was the operator arrested?
Yes, he was.
No more questions.
Cross-examination.
Good morning, Officer Sheehan. Please, the court, I'd like to focus on one of the photos that was just introduced as exhibit 1. Do you recognize this?
I do.
Sorry, sure. Go ahead. Okay. There's, of this set of 3 and that makes up exhibit 1, there's only one that I'm really interested in here, and that's this one. So, Your Honor, am I permitted to circulate photos to the jury, or can he only report what he sees on those?
They can be published, but if you're going to ask questions of the witness, pertaining to that,
Okay. So thus far, the image that is in front of you has just been characterized as vehicular damage, but can you get more specific? Like what collision pattern is that consistent with? Is it, like, for instance, would you look at that photo and say that truck has T-boned another vehicle?
Not based on this photo, no.
Okay. So based on that photo, what kind of vehicular incident happened with that, or would have inflicted that?
There's scratches all down the right-hand side of the truck bed.
Okay. Scratches, is there deformation of the metal at all? Is the body or the frame damaged, or is it just purely paint damage?
I can't see the frame from the photo shown here, so I don't know if the frame of the vehicle has any damage.
But to the extent that a portion of the vehicle is visible in the photo, does there appear to be any frame damage in that visible portion?
Excuse me, but I'm not able to see the frame of the vehicle in this photo at all.
What are you able to see in that photo?
The right-hand side of the truck bed, as well as the right rear.
Maybe I'm not using the right vehicular terminology with frame, but just the outermost part of the outermost body panel, let's say, that's got that exterior paint on it. So that's, you see that, and what else?
The right rear wheel, I
Okay.
can also see that.
Okay. And so the right rear wheel appears undamaged.
From this photo, yes.
Yeah, right. No, everything pertains to the photo in front of you. So the term damage, to the extent that it's being applied to the image captured in that photo, is just, what, a scratch on the paint?
Yeah, I can't tell if there's any further indentations, if that's what you're trying to allude to, I can clearly see a long black scratch, series of scratches down the right-hand side of the vehicle. That's what I can see in this photo.
Okay. All right. One more question. So the other vehicle, the Commonwealth mentioned the name of the driver of the other vehicle that was involved in that collision, but I didn't retain that. Was it Rivera?
Your Honor, I believe Mr. Cook had actually read that individual. I did not.
Oh, I'm sorry. Right, you are. Okay, so whatever party that was, how would you characterize the damage that was inflicted on their vehicle by that collision?
I didn't stop to take a look at their vehicle.
But did you see anything? Describe for a moment, if you will, what I'm getting at is the word collision is awfully broad, and I'm trying to narrow it down to be more applicable to what the deal was. So is that, so what kind of, collision are we talking about? Like, would you say that the word sideswipe captures it better than head-on?
I would agree that a sideswipe would describe what happened better than calling it a head-on collision.
Okay. If you had the opportunity in the situation to stop and check on their safety and welfare and evaluate their vehicle, where would you have imagined to start looking at the vehicle for damage?
On the driver's side of their vehicle?
Okay. I have two more photos that I'd like to please the court that haven't been entered already. Oh, sure. These are still from discovery. Well, does it need to be identified first?
Listen to the judge.
Okay. I'm not trying to. Okay. Can you describe what these are? Would you?
There are two photos of the mechanic shop that was involved in the incident.
Okay. The mechanic shop. So there's lawn damage there. Is there? Why do you think that those photos were taken?
To show the tire marks through the lawn.
Okay.
I would imagine.
But just to be clear, that lawn that's depicted in those photos is not at the same place that the alleged infliction of lawn damage that first brought this incident to your attention. That was a different property?
That's a different location.
Okay, that's my understanding as well, and unfortunately we don't have photos of that damage either. And so, to the best of your knowledge, so that there's two grassy lawn areas
Right.
that are both alleged to have incurred damage.
Right. No, I wrote in my report that the first time I witnessed the vehicle drive on the lawn, passing a car in front of him on the right-hand side, I noted in the report that I did not observe any property damage at that residence.
Yeah, okay.
So I did not write that there are two separate lawn types of damage.
Understood. Okay. So the photos that you've got in front of you depict a property that's owned by somebody who was on the Commonwealth's witness list for today that didn't make it. The owner of the business, Mark McNulty, who was not able to be with us. So I'm trying to repurpose some of my cross questions that I was intending to ask him for you, and that's why this is there. But all right, that's fine. One last. Let's talk about pedestrians. You made two different references to pedestrians. You talked about, you made a general comment about how presumably due to it being election day, that the sidewalks were thronged with people in front of 1480 Main Street, which is the address that isn't pictured in those photos, where the first of the two lawn traversals is alleged to have happened. Is that right?
The objection, Your Honor. long,
So, Mr. Cunningham, I'm going to explain the section as to, I actually did not, if you could phrase your question as a question, and I'm going to ask that you re-ask the question, just reframe it as a question.
Yes, Your Honor. I came away from your testimony on direct with the impression that when you were traveling down Main Street and first noticed my vehicle engaged in the alleged charges here, that there was heavy pedestrian traffic, heavy foot traffic in that area also. Is that, have I formed a fair impression from your testimony by thinking that?
Yes.
Okay. So would you object to the terminology throng? Would you say that it would be too much to say that the sidewalk at that time was thronged with pedestrians?
Can you rephrase your question? I'm sorry.
I'm trying to get a sense of how busy was it? You say it was busy, it was very busy. So does that mean that were there people actually walking, or were they standing and holding signs and protesting?
I'll describe the foot traffic in town that day, generally speaking, as heavy, just based on the fact that it was election day, and for a smaller-ish town, there's not a whole lot of foot traffic on sidewalks compared to this day with election day. So there were people, to answer you directly now, there are people both walking through sidewalks, but there are 4 or 5 different election sites in town on election day. So there's people both walking and standing, picketing, and what have you.
Okay.
I would describe that day.
Okay. But in your experience with the area and with Route 38, it definitely stood out to you as abnormal how many pedestrians there were?
No, it seemed normal based on the events of the day.
Well, that's what prompts the question, is you're saying that you're speculating that the observation of heavy pedestrian traffic was related to the fact that it was election day, as if to say, if it weren't election day, there wouldn't have been that many pedestrians.
Exactly.
Okay, all right. So, okay. How about the 2 pedestrians that it actually wasn't originally your testimony in the complaint, it was attributed to witness McNulty, the owner of that shop, but he says that there were 2 pedestrians that were in that area that is presumably now depicted by that photograph that I handed you that shows the tire tracks? Okay. So, but you in your pursuit, or in your role in this pursuit, were not actually there to be able to see that there were 2 witnesses there. You're just echoing what was said in the report based on McNulty?
That's correct.
Okay. No further questions, Your Honor. Thank you. Thank you, officer. Did you want to identify these, or? Sorry.
I don't know what you're attempting to do. Why don't we go step by step?
I just wanted to make it possible for somebody in the future reviewing this case to know what photos he was testifying against. I thought it was standard procedure that if somebody was going to be, if a witness was going to be presented with evidence that they can.
Exhibits?
Yeah.
Are you objecting to the
The Commonwealth did not object, Your Honor.
That have been made. No. Members of the jury, that means that all the evidence that the Commonwealth was going to intend on producing for this trial has now been produced and presented to you. The law does require me to speak with the litigants outside of your so I am going to hold a just brief recess, and then I will bring you back in and we will continue moving forward. You did hear testimony, as I indicated previously. You are not permitted to talk amongst yourselves about anything that you may have seen or heard while the court was in session, but do feel free to talk amongst yourselves about anything else. We'll see you back here very shortly.
Court, all rise for the jurors.
I have nothing I intend to do except to take the stand.
Commonwealth, the evidence that were presented in court, I do find that the Commonwealth has been identified part finding that would have been filed would have been denied.
Thank you, Your Honor.
Take the witness stand now?
Yes, Your Honor.
Okay, so this is one of the witnesses how we're going to proceed. I'm going to bring the jury back in. I'm going to let them know that the defendant has a right to present evidence if they want to, but you're not obligated to do so. And I'm going to ask you whether or not you want to present any evidence. You'd say you want to testify if that's what your election is. And then what I'm going to do is I'm going to have you take the witness stand. You're going to be sworn in, and then you will testify in a narrative form. You're not going to have any use of the aids or anything to read off of. Recollection and memory of the events. And then once that's complete and you're done with that, the Commonwealth's going to get the opportunity to cross-examine you, okay?
May I introduce more photos to speak to?
If you have photos that you'd like to present,
They're already in discovery. Sorry.
provide them to the Commonwealth.
These, I believe, are you talking about the photos that were provided by Commonwealth for discovery purposes?
I'm just selecting from the discovery that the Commonwealth provided.
Oh, so it's stuff that's already in as evidence?
Well,
Not in evidence
it-
already, but it was provided.
But in other words, you've already seen these photos. This is part of the discovery
Yes.
package?
Yes.
All right, that's fine. And you plan on trying to introduce those photos for yourself?
yeah, I would like to be able to refer to these in my narrative testimony.
Okay. Any objection to that?
May I ask in advance as to the relevancy,
I don't know.
largely the photos.
To please the court?
Largely, these are photos taken, I'm assuming, is from inside the vehicle, Your Honor.
That's correct, Your Honor.
Okay. What's the relevance?
It gets to my intent that I spoke to in the opening.
And you want an opportunity to be able to present that to the jury?
Yes, Your Honor.
Okay. Any objection?
No, Your Honor.
So I'm going to allow you to refer to these during your narrative.
Thank you, Your Honor.
Any objection to these being marked?
No, Your Honor.
Okay. Yeah. All right, anything else before I bring back?
Not for me, Your Honor.
No, Your Honor.
All right.
All rise for the jury. course, not back in session, maybe seated, thank you.
All right, notice the jury. What happens now is that the defendant gets an opportunity to present a defense if he wishes to do so, but as I told you in my opening instructions, he's not obligated to do so because the burden is always and stays with the Commonwealth. So this time we're going to turn to Mr. Cunningham to find out. Mr. Cunningham?
I would like to testify and speak to the exhibits.
Solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Morning. I'm taking a stand just to elaborate on the motive/intent aspect of this case. But by way of introduction, I'm 47 years old. I'm divorced. I have no biological kids. I've lived in Wilmington for the last 6 years. I've been employed as a software engineer since 1994. And the last 13 years of that career has been in Boston working at financial companies, asset management, that type of thing. And I was employed at such a firm at the time of these events. I don't have a family, but I make good money and I spend my money supporting my family of origin, my parents and siblings, and what friends I have. But I don't have a lot of friends because I'm kind of a political loudmouth and a political activist, and I'm willing to wade into political discussions when most people are afraid to do that. And so that I mentioned that character trait because it does have some bearing on what was motivating me that day. So the morning of Election Day, I woke up and was dismayed. Being a leftist, which is a label I don't mind taking, I could see the writing on the wall and was dismayed at the near certainty that Donald J. Trump was going to win the election that day. And so I was determined to engage in some kind of active election interference or disruption, even if only symbolic, even if in the spirit of old school 1960s style civil disobedience, non-violent civil disobedience. And I want to stress that violence was not violence is not in my heart generally as a person, but it certainly wasn't in my heart that day. That day, what I had settled on as the thing I was going to do for my symbolic political stand was to distribute some leftist literature at polling places. And so I was introduced. Can I circulate this? I don't actually need to describe it. I just want them to see. These are photos that were taken by the police.
You may have that published to the jury.
Thank you. These are photos that were taken by the Commonwealth while they were examining my vehicle. This is a sampling of some of the leftist literature that I was intending to distribute that day. So there's nothing earth-shattering in there, but I just want to establish that there is an element of premeditation to what happened that day, even though it didn't end up being what I premeditated. So that speaks to what was truly my intent. But the first place that I went that morning was to the Wilmington Police Department. Now, the police officer that testified earlier was from the Tewksbury Police Department, and that's because this vehicular chase, Route 38 northbound in Massachusetts, passes through both towns. They abut each other. This all began in Wilmington and then became a law enforcement issue only when it was in Tewksbury. But my activities that day began in Wilmington, and I went to the Wilmington Police Department and went and asked them if I could be given or told some kind of instruction or guidelines on what the rules are at polling places on election day, because I wanted to know how disruptive would I have to be in order to get arrested. So the duty officer at Wilmington Police Department was courteous and receptive, and they immediately understood why I was asking. And apparently the Commonwealth had produced, the month prior, William Francis Galvin had promulgated a document called Electioneering Within 150 Feet of Polling Places that just lays out, this is what you're allowed to do, this is what you're not allowed to do. And it said that if I were to, one word, to loudly distribute propaganda or disruptively distribute propaganda within 150 feet of a polling place, then that would do the trick. So, and I also asked the Wilmington Police Department for the locations of the polling places. There are 3 in Wilmington at that time. And so they gave me the list of those as well. And the whole encounter was peaceful and courteous and mutually respectful. So I took that information and I drove to the first of the 3 polling places, and it was the Wilmington High School. And I will, part of the reason I was cross-examining Officer Sheehan about the pedestrian traffic was because I've lived in the area for 6 years. I've been up and down that stretch of Route 38 hundreds of times. And in the difference I observed was a slight increase in pedestrian traffic, all of which were stationary protesters. There were no people ambulating up and down the sidewalks, more than usual. But vehicular traffic was very heavy that day, extremely heavy, disproportionately heavy. It took me much longer just to get to the polling place than it would normally have. And so that made me, with these intentions that I was harboring, it made me excited because I thought, oh, that means that the polling place is going to be packed and there are going to be a lot of people there, and that there will really be a disruption, actually. And when I got inside, it was the cafeteria of this high school had been cordoned off and pressed into the service. And it was, contrary to the vehicular traffic outside, it was dead. There was hardly anybody there. I was the only person. There were 2 poll workers there, and there was another Wilmington Police Department officer stationed outside the entrance. But other than that, I was the only person in there. So that kind of took the wind out of my sails a little bit. So I just sort of just calmly put some of the literature that you saw on some of the cafeteria tables, and then just kind of looked around like, really, this is it, and left. And then I thought, all right, well, if turnout is that low, then that's a really bad sign for the country, but maybe it's just this polling place. So let me go to the next polling place. There are 3. And so it was the traversal to the next polling place from the first one that is what got me on Route 38 and got me into a place where all the events that the Commonwealth has already described happened. And vehicular traffic was extremely heavy, and I was in a state of some anxiety because of this unorthodox thing that I had chosen to do intentionally. And so, you know, the ADA himself said it. You know, there was a poor decision in my decision to try to pass slow vehicles on 38 that were in my way, that I was eager to get where I was going. And again, my recollection does not align with Officer Sheehan's about how heavy the pedestrian traffic was that day. There was one group of protesters on the sidewalk right outside of election polling place number 1 that I had already passed by the time these events began. But aside from that, there was no increase that I could see over the norm from pedestrian traffic in that area. So it was just, from what I was seeing and what I was engaged in, it was a purely vehicular situation. And within that vehicular situation, I did take advantage of a gap in the oncoming traffic and attempt to make a pass, contrary to how the lines were indicated in that part of the road. And then suddenly I found myself in a police chase, and I thought, well, if I immediately pull over, and deal with the ticket and everything else, then I guess I will have more expense, and then we'll just travel on to polling place number 2 of 3 in Wilmington, where I do this thing intending to be disruptive and get arrested. Or if my intention was to get arrested as a symbolic protest of the election on election day, then here it's unfolding already. I'm already in the middle of a police chase. I might as well just prolong this. This is my opportunity to get myself arrested on election day, as was my rationally concluded, premeditated intent. I really can't refer to any other notes, Your Honor. Okay. I do also wish to dispute Officer Sheehan's testimony about the 2 pedestrians that had to leap out of the way at Ronnie's Car Care. Again, the proprietor of Ronnie's Car Care, Mark McNulty, who was supposed to be here and is not here, he is the originator of that assertion, and that assertion showed up in the police report from the beginning. It's my belief that that's a false assertion, and I don't recall it that way. I don't recall there being, I chose that spot to steer towards in my exit off of the road precisely because I didn't see any obstruction that would have been jeopardized by doing that. So that I must contest. That's it.
No question.
All right, thank you very much.
Thank you, Your Honor.
All right, Mr. Cunningham, any other witnesses or?
No, Your Honor.
All right, you rest.
I have a closing statement, but I rest, yeah.
So, minute after the rest means that all the evidence that we have going to present to you in this trial has now been The law does require me to have a meeting with the litigants, and if it has to be done outside of your hearing, it's just required. And so I am going to hold that meeting with them now. I am going to tell you that when I first started my initial instructions to you, I told you that lunch break is between 1 and 2 o'clock. And given what my meeting is going to be about with the litigants, it's going to probably take us right to that 1 o'clock hour. So I am going to release you for lunch and have you come back for 2 o'clock promptly. While you are in a recess, I'm going to ask that you talk about the evidence that you've heard received while this court is in session. You also may see the litigants and anybody else involved in this trial out in the hallway. I'm not going to speak with them. It's not because they're being rude in any way, but it's just because they're following the rules of the court while the trial's in session. So please understand that. And otherwise, I'm going to ask that you listen to the court officers as they provide you with details about where and what time to be back. And we'll see you back here approximately 2 o'clock. Thank you.
Court, all rise for the jury.
Seated. Right. Is there anything odd or exotic or outside of the norm that the parties want me to consider giving in my final charge to the jury?
Nothing I can think of, Your Honor.
Anything else, sir?
No, Your Honor.
Okay, fair enough. So this is what I plan on giving to the jury. Function of the judge, function of the jury, what is evidence, credibility of the witnesses. Discrepancies in testimony, prejudice, sympathy, interested witness, direct and circumstantial evidence, innocence, burden of proof, unanimity. I'm also going to give pro se defendant charge.
Your Honor, may I ask what that entails? I'm not familiar with that.
I've already given that instruction in my pre-charge to the jury, but
Okay.
it explains to them that you have decided to represent yourself in this case, and that you have a right to do that, and that it should not be a factor that they consider in deciding whether or not you're guilty or innocent. All right. So reasonable doubt, and then I'm going to go into the charge of leaving the scene of an accident or property damage, negligent operation, and refusing to stop for a police officer. Mr. Cunningham, when we get back at 2 o'clock, it is your responsibility at that point to give your closing statement. The way that it works is that the order flips from the opening statements. So instead of going last in the closing arguments, you're actually going to go first. So you're going to give your closing statement when we get back from the jury, with the jury.
Okay.
And then the Commonwealth is going to give their closing argument after you get done doing yours, okay? Any questions about that?
No, Your Honor.
Okay. So we'll be in a recess until 2 o'clock. Please be prompt and come back.
Right.
When we were last together, I told you that the defendant had arrested and I indicated that all the evidence that was ever going to be produced and presented to you in this trial has now been presented. What happens now is that the litigants are going to give you their closing arguments. And the same close attention I saw that you were giving the witnesses when they were testifying, I'm going to ask that you give that same close attention to the litigants when they give their closing statements. The closing statements are not evidence, as I indicated earlier, but they are still very important. They're important because they're the contingents of the parties and how they see the evidence and how they would like you to start to see the evidence from their own individual perspective. With that, I'm going to turn to Mr. Cunningham, and he's going to provide us his closing statement.
Just because I'm here today defending my actions doesn't mean that I'm proud of them. I'm sorry for the fear and alarm that I caused the people that I endangered on Election Day. I owe an apology to the people of Middlesex County, and I'm sorry. I've been a pathetic and ridiculous man my entire life. If anyone has ever given me respect, they've been mistaken. If I've ever felt pride in myself, I've been mistaken. But it's only recently that I've learned what it is to be despised. I've spent the last several months since this incident happened, and maybe even before, being the most despised man in Middlesex County. There aren't many avenues of redemption available for a person who is pathetic and despised, but here's the one I'm aiming for. All I have ever wanted is to be fully accepted as a community member in good standing by the people I live and work with in Middlesex County. And I'm determined to prove it. And I prove it by standing here today and accepting whatever punishment the people of Middlesex County feel I deserve. And I forgive me a moment. It's important to me that I do this I'm sorry, Your Honor. Can I call a brief recess? I just need a minute. A sidebar even. No, I mean, like, I wrote this down and I can't remember it now. I'm trying to play. This is harder than I thought it would be. I'm trying to prove that I want to take my place in the community by staying here and accepting whatever punishment is given me, instead of running away and hiding behind a high-priced legal team, the way our president, so beloved by so many in Middlesex County, always does. There are many respects in which President Trump is my better, but there's one respect in which I am his better. Let no one say that his respect for the rule of law or for American jurisprudence exceeds mine. If I'm found guilty, and if I'm sentenced to a jail term, then I invite the people of Middlesex County to come down and visit me in jail, where I'll be happy to listen to whatever censure or insult or wisdom they think I need to hear. Thank you.
Hello again. You saw the defendant take a stand and essentially admit to what occurred on November 5th, 2024 in the town of Tewksbury. He said he was operating his vehicle. He said he was driving along Main Street, that an accident occurred while he was trying to get around another vehicle. The police then, he said, he led them on a chase through town. And this is corroborated by the Officer Sheehan, who testified that he witnessed the defendant before you, Mr. Cunningham, as well as his vehicle get into an accident with another vehicle, take off. When his emergency lights were turned on in his fully marked police cruiser in his uniform, the defendant just kept going for about another half mile before he eventually pulled over. Officer got out of his vehicle, and then the defendant took off, ultimately going right through, and I believe he said 3 other cruisers had set up a stop, and he was able to go through that. Regarding, because it has come up with regard to damage of a vehicle, the extent of the damage really doesn't matter. What matters is that the damage occurred, and we have in evidence the scratch marks that had happened to the defendant's vehicle following what Officer Sheehan had witnessed. And with regard to the defendant's intent while he was operating that vehicle, the judge is going to give you the jury instructions, and I ask you just to listen carefully to them, because you're going to hear that intent isn't there. It doesn't matter what was happening inside the defendant's head, what he was thinking. It's his actions that matter. And you have heard his testimony where he admits to those actions, as well as that, again, being corroborated by Officer Sheehan, his observations that day. So when you go back, I ask you now to find the defendant guilty of leaving a scene of property damage, negligent operation of a motor vehicle, and failure to stop for a police officer. Thank you.
All right, thank you. All right, members of the jury, you are about to begin your final duty, which is to decide the fact issues in the case. Before you do that, I'm going to instruct you on the law. It was obvious to me that throughout the trial that you faithfully discharged your duty to listen carefully to all the evidence and observe the witnesses. I'm now going to ask you to give me that same close attention as I instruct you on the law. My function as the judge in this case has been to see that this trial was conducted fairly, orderly, and efficiently. It was also my responsibility to rule on what you may consider as evidence and to instruct you on the law which applies to this case. It is your duty as jurors to accept the law as I stated to you. You should consider all of my instructions as a whole. You may not ignore any instruction or give special attention to one instruction. You must follow the law as I give it to you, whether you agree with it or not. Your function as a jury is to determine the facts of this case. You alone determine what evidence you believe, how important any evidence is that you do believe, and what conclusions to draw from that evidence. And in making these determinations, you are to use all of your common sense, life experiences, and good judgment. You are to decide what the facts are solely from the evidence admitted in this case. In evaluating the evidence and determining the facts, keep in mind that we all tend to perceive information and form opinions based on our own personal experiences and backgrounds. This tendency may cause us to hold biases of which we may or may not be conscious. As I previously instructed you, you must not allow bias, whether held consciously or subconsciously, to interfere with your ability to fairly evaluate the evidence, apply the law as I instruct you, or render a fair and impartial verdict. Or render a fair and impartial verdict based on the evidence before you. The evidence consists of the testimony of the witnesses as you recall it, and any documents or other things that were received into evidence as exhibits. Picture in your minds that all the evidence went into a box. That box is now closed. Your verdict must be based on what is in the box, together with any reasonable inferences you choose to draw from it. Your determination of the facts must not be based on speculation or conjecture. Do not guess about things. During your deliberations, one of you might say, "What about this?" or "What about that?" Well, if the this or the that isn't in the box, if it's mere guesswork, do not consider it. In short, base your verdict on the evidence and any reasonable inferences you choose to draw from it, but do not guess or speculate about things which there is no evidence. Some things that occurred during a trial are not evidence, and you may not consider them as evidence in deciding the facts of this case. The complaint itself is not evidence. A question put to a witness is never evidence. Only the answers are evidence. Also, you may not consider any answer that I struck from the record and told you to disregard. Do not consider such answers. Anything that you may have seen or heard when the court was not in session is not evidence. The opening statements and closing arguments of the litigants are not a substitute for the evidence. They are only intended to assist you in understanding the evidence and the contentions of the parties. If your memory of the testimony differs from the litigants, you are to follow your own recollection. You should not consider anything I have said or done during this trial as an indication of my opinion as to how you should decide the defendant's guilt or innocence. In evaluating a witness's testimony, you have to decide what testimony to believe and how much weight to give that testimony. You should give the testimony of a witness whatever degree of belief and importance that you judge it is fairly entitled to receive. You are the sole judges of the credibility of a witness. You may believe everything a witness says, or only part of it, or none of it. If there are any conflicts, discrepancies, or inconsistencies in the testimony, you should examine them carefully. You may consider whether a witness was candid or guarded, responsive or evasive, and whether the testimony is reasonable or unreasonable, probable or improbable. You may take into account how good an opportunity a witness had to observe the facts about which the witness testifies, and whether the testimony seems accurate. You may also consider evidence, if any, about a witness's motive for testifying, whether a witness displays any bias in testifying, and whether or not a witness has any interest in the outcome of the case. In deciding whether to believe a witness and how much importance to give a witness's testimony, you must look at all the evidence, drawing on your own common sense and life experiences. Consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you have gone to the jury room to decide the case, and you and your fellow jurors have discussed the evidence. Keep an open mind until then. Once you have determined the facts, apply the law as I explain it to you to the facts in order to decide the verdicts. In evaluating testimony, you may find inconsistencies or discrepancies. They may or may not cause you to discredit such testimony. Consider whether they involve important facts or only minor details, and whether any inconsistencies or discrepancies result from innocent lapses of memory or intentional falsehoods. It would be improper for you to allow any feelings you might have about the nature of the crime to interfere with your decision. Any person charged with any crime is entitled to the same presumption of innocence, and the Commonwealth has the same burden of proving the defendant's guilt beyond a reasonable doubt. The fact that the prosecution is brought in the name of the Commonwealth entitles the prosecutor to no greater consideration and no less consideration than any other litigant, since all parties are entitled to equal treatment before the law. The word verdict comes from two Latin words meaning to tell the truth, and that is what the law looks to your verdicts to do based solely on the evidence in this case. Justice is done when a verdict is returned based on the evidence and the law, regardless of whether the verdict is guilty or not guilty. In many criminal cases, there is an element of sympathy which surrounds the trial. You may not permit sympathy to affect your verdicts. The fact that a witness may have some interest in the outcome of this case doesn't mean that the witness isn't trying to tell you the truth, as that witness recalls it or believes it to be. But the witness's interest is a factor that you may consider along with all the other factors. There are two types of evidence which you may use to determine the facts of a case: direct evidence and circumstantial evidence. You have direct evidence where a witness testifies directly about the fact that is to be proved, based on what he claims to have seen or heard or felt with his own senses. And the only question is whether you believe the witness. You have circumstantial evidence where the witness cannot testify directly about the fact that is to be proved, but you are presented with evidence of other facts, and you are then asked to draw reasonable inferences from them about the fact which is to be proved. Let me give an example. Your daughter might tell you one morning that she sees the mailman at your mailbox. That is direct evidence that the mailman has been to your house. On the other hand, she might tell you only that she sees the mail in the mailbox. That is circumstantial evidence that the mailman has been there. No one has seen him, but you can reasonably infer that he has been there since there is mail in the box. The law allows either type of proof in a criminal trial. There are two things to keep in mind about circumstantial evidence. The first one is that you may draw inferences and conclusions only from facts that have been proved to you. The second rule is that any inferences or conclusions which you draw must be reasonable and natural, based on your common sense and experience of life. In a chain of circumstantial evidence, it is not required that every one of your inferences and conclusions be inevitable, but it is required that each of them be reasonable, that they all be consistent with one another, and that together they establish the defendant's guilt beyond a reasonable doubt. If the Commonwealth's case is based solely on circumstantial evidence, you may find the defendant guilty only if those circumstances are conclusive enough to leave you with a moral certainty, a clear, settled belief that the defendant is guilty, and that there is no other reasonable explanation of the facts as proven. The evidence must not only be consistent with the defendant's guilt, it must be inconsistent with his innocence. Whether the evidence is direct or circumstantial, the Commonwealth must prove the defendant's guilt beyond a reasonable doubt from all the evidence in the case. It was the duty of both litigants in this case to object when the other side offered evidence which that litigant believed was not admissible under our rules of evidence. We also had an obligation to ask to speak to me at the judge's bench about questions of law, which the law requires me to rule on out of your hearing. The purpose of such objections and rulings is not to keep relevant information from you, just the opposite. They are to make sure that what you hear is relevant to this case, and that the evidence is presented in a way that gives you a fair opportunity to evaluate its worth. You should not draw any inference, favorable or unfavorable, to any of the litigants for objecting to proposed evidence or asking me to make such rulings. That is the function and responsibility of the litigants in this case. The defendant has decided to represent himself in this trial and not use a lawyer. He has a perfect right to do that. His decision has no bearing on whether he is guilty or not guilty, and it should have no effect on your consideration of the case. The complaint against the defendant is only an accusation. It is not evidence. The defendant has denied that he is guilty of the crimes charged in this complaint. The law presumes the defendant to be innocent of the charges against him. This presumption of innocence is a rule of law that compels you to find the defendant not guilty unless and until the Commonwealth produces evidence from whatever source that proves that the defendant is guilty beyond a reasonable doubt. This burden of proof never shifts. The defendant is not required to call any witnesses or produce any evidence, since he is presumed to be innocent. The presumption of innocence stays with the defendant unless and until the evidence convinces you unanimously as a jury that the defendant is guilty beyond a reasonable doubt. It requires you to find the defendant not guilty unless his guilt has been proved beyond a reasonable doubt. Your verdict, whether he is guilty or not guilty, must be unanimous. The burden is on the Commonwealth to prove beyond a reasonable doubt that the defendant is guilty of the charges made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt. For everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to a moral certainty, we mean the highest degree of certainty possible in the matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That is what we mean by proof beyond a reasonable doubt. Turning to the charge of leaving the scene of an accident involving property damage, The defendant is charged with knowingly leaving the scene of an accident involving property damage. In order to prove the defendant guilty of this offense, the Commonwealth must prove 4 things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that while the defendant was operating the vehicle, he caused damage to another vehicle or property either by colliding with it or in some other way. Third, that the defendant knew he had collided with another's property, or had in some way caused damage to another's property. And fourth, that after causing such damage, the defendant did not stop and make known his name, home address, and the registration number of his motor vehicle. A person operates a motor vehicle not only while doing all of the well-known things that drivers do as they travel on the street or highway, but also when doing any act which directly tends to set the vehicle in motion. The law is that a person is operating a motor vehicle whenever he or she is in the vehicle and intentionally manipulates some mechanical or electrical part of the vehicle, like the gear shift or ignition, which alone or in sequence will set the vehicle in motion. A driver has a duty to immediately stop at the scene and offer the specific information required: name, home address, and motor vehicle registration number. This duty is not satisfied by stopping at some remote place or by being passively willing to answer inquiries. You may find that the defendant was the operator of the motor vehicle, even if no witness saw him driving the vehicle. If there is enough circumstantial evidence to prove to you beyond a reasonable doubt that the vehicle was operated and that the defendant and no one else was the operator of the vehicle. The extent of damage is not relevant except to the extent that it may be circumstantial evidence of whether or not the defendant knew that there had been a collision. Turning to the charge of operating negligently so as to endanger. The defendant is charged with operating a motor vehicle negligently in a manner that might endanger the public. To prove the defendant guilty of this offense, the Commonwealth must prove three things beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that the defendant did so on a way or in a place where the public has right of access, or in a place where members of the public have access as invitees or licensees. And third, that the defendant did so in a negligent manner so that the lives or safety of the public might have been endangered. A person operates a motor vehicle not only while doing all of the well-known things that drivers do as they travel on the street or highway, but also when doing any act which directly tends to set the vehicle in motion. The law is that a person is operating a motor vehicle whenever he or she is in the vehicle and intentionally manipulates some mechanical or electrical part of the vehicle, like the gear shift or the ignition, which alone or in sequence will set the vehicle in motion. Folks, I left one charge or portion of the charge in my lobby. I just need to go pick it up and I'll be right back. I'll be back in about 2 minutes.
All rise. If you guys want to stretch, feel free to stretch.
Rise.
May be seated.
The Commonwealth was proved beyond a reasonable doubt that the defendant operated a motor vehicle on a public way. Any street or highway that is open to the public and is controlled and maintained by some level of government is a public way. This would include, for example, interstate and state highways, as well as municipal streets and roads. In determining whether any particular street is a public way, you may consider whether it has some of the usual indications of a public way. For example, whether it is paved, whether it has street lights, street signs, curbing, and fire hydrants, whether there are any buildings along the street, whether it has any crossroads intersecting it, and whether it is publicly maintained. The third thing the Commonwealth must prove beyond a reasonable doubt is that the defendant drove negligently in a manner that might have endangered the lives or safety of other people. A person acts negligently when they fail to use due care, that is, when they act in a way that a reasonable person would not act. This can happen either by doing something that a reasonably prudent person would not do under those circumstances, or by failing to do something that a reasonably prudent person would do. The defendant acted negligently if they drove in a way that a reasonable person would not have, and by doing so created an unnecessary danger to other people, a danger that they could have avoided by driving more carefully. The fact that an accident occurred is not by itself evidence that the defendant was negligent. You must examine all the evidence about how the accident happened in order to determine whether any negligence was involved, and if so, whether that negligence was the defendant's. In determining whether the defendant drove negligently in a manner that might have endangered the public, you should take into account all of the facts of the situation: the defendant's rate of speed and manner of operation, the defendant's physical condition, and how well the defendant could see and could control the vehicle, the condition of the defendant's vehicle, what kind of road it was, and who else was on the road, what time of day, and whether and the condition of the road were, what any other vehicles or pedestrians were doing, and any other factors that you think are relevant. If you find that the defendant acted negligently, the defendant's intent is not relevant. You are not required to find that the defendant intended to act negligently or unlawfully. This is in the category of situations where public safety requires each driver to determine and to adhere to an objective standard of reasonable behavior. Therefore, the defendant's subjective intent is irrelevant. The issue is whether or not the defendant drove as a reasonable person would have under the circumstances. So there are three things that the Commonwealth must prove beyond a reasonable doubt. First, that the defendant operated a motor vehicle. Second, that the defendant did so on a public way or in a place where the public has right of access, or in a place where members of the public have access as invitees or licensees. And third, that the defendant did so in a negligent manner so that the lives or safety of the public might have been in danger. If the Commonwealth has proven all three elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. Turning to the charge of refusing to obey a police officer. The defendant is charged with refusing to obey a police officer. To prove the defendant guilty of this offense, the Commonwealth must prove four things beyond a reasonable doubt. First, that the defendant was operating or in charge of a motor vehicle. Second, that a police officer signaled the defendant to stop. Third, that the defendant refused the officer's request or refused or neglected to stop. And fourth, that the police officer was either in uniform or had their badge conspicuously displayed on the outside of their clothing. To prove the first element, the Commonwealth must prove beyond a reasonable doubt that the defendant was operating or in charge of a motor vehicle. A person is operating a motor vehicle whenever they are in control of it. A person may be in control of a vehicle if they are in close physical proximity to it, even if they are not actually in the vehicle. You should consider all of the evidence and any reasonable inferences you draw from the evidence in determining whether the defendant was operating or in control of a vehicle. To prove the second element, the Commonwealth must prove beyond a reasonable doubt that the police officer signaled the defendant to stop. To prove the third element, the Commonwealth must prove beyond a reasonable doubt that the defendant neglected to stop and or refused to stop. You are to draw from the evidence in determining whether the defendant neglected to stop or intentionally refused to stop. To prove the fourth element, the Commonwealth must prove beyond a reasonable doubt that the police officer was in uniform, had their badge conspicuously displayed on the outside of their clothing, or in some way effectively notified the defendant that they were a police officer. A police officer is any constable or other officer authorized to make arrest or serve process. If the Commonwealth has proven all four elements beyond a reasonable doubt, you should return a verdict of guilty. If the Commonwealth has failed to prove one or more of these elements beyond a reasonable doubt, you must return a verdict of not guilty. All right, can I see the parties of sidewalk, please? gentlemen, when we impanel a jury at the beginning of the trial, we never know whether some personal emergency will arise during the course of the trial, which will require that one of the jurors be excused from further jury duty. To avoid having to start the trial over again if that should occur, we impanel 7 jurors, even though the case will be eventually only decided by 6 of you. The time has now come to reduce you to that number of 6. The clerk will draw one of your names at random. That juror will be designated as an alternate juror and will not take part in your deliberations unless it is necessary to provide a substitute for one of the other jurors. If fate makes you the alternate juror, please don't take it personally. Your presence up to this point and your continuing availability, if you should be needed, in and of itself is an important contribution to the administration of justice. The court officers will make you as comfortable as possible as the jury deliberates. Mr. Clerk will now reduce you to that number of 6, please.
Juror number 73 in seat 5, you are hereby designated as the alternate juror. You will be kept separate and apart in the attendance of the court officer unless you are later drawn upon to replace a sitting juror. The court officer will show you where to go in a moment.
All right, can you just raise your hand for me, please? All right, thank you. Mr. Clerk is now going to select a 4-person for our jury.
Juror number 67 in seat 2, you are hereby designated as the 4-person of the jury.
All right, can you raise your hand for me, please? All right. Madam Forley, you have some special instructions I'm going to provide you now, and some special duties that you're going to perform during the deliberation. Madam Forlady, when all 6 jurors have agreed unanimously on a verdict, you should record that verdict on the verdict slips, date it, and sign it. Then inform one of the court officers that you've reached a verdict and be brought back into the courtroom to record that verdict onto the record. What you're going to see is that we have 3 verdict slips for each of the 3 charges within the complaint. It has the caption heading, it has the docket number, it says, "We, the jury, unanimously return the following verdict." It has the charge, leaving the scene of property damage, it has a space for guilty and another space for not guilty. Whatever the unanimous decision will be, you're going to check that off, sign it as the 4-person, and date it where the space is provided. The same applies with negligent operation. You're going to check off the box, whichever applies, whatever the unanimous decision is. You're going to sign it and date it. And lastly, also for failure to stop the police. Check off the box, whatever the unanimous decision is of the jury. You're going to sign it and date it. We're going to provide you with an envelope. I'm going to ask that you place the verdict slips into the envelope, seal it, and then get one of the court officers' attention to bring you back into the courtroom so that we can read it onto the record. If the jury has any questions during your deliberations, you should write them out on a separate piece of paper, fold it up, and give it to the court officer to bring back to me. You are not to make any use of any cellular telephones or any other personal wireless devices during your deliberations. Incoming or outgoing calls or other electronic communications may disrupt the deliberative process and allow for the receipt of improper extraneous information. You are not to conduct any outside research or investigation by means of the internet or otherwise about the law or the facts of this case. The clerk is now going to swear in the court officers who will escort you to your deliberations.
Mr. Court officers, you solemnly swear that you will take charge of this jury, that you will keep them together in some convenient place until they have agreed, that you will not speak to them, nor suffer anyone else to speak to them, except by order of the court, or to ask them if they have agreed, so help you God.
I do.
All right, members of the jury, you may now retire to consider your deliberations.
Court, all rise for jurors.
stay close by, and we will get your attention as soon as we hear back from the jury. We'll be in a recess until